thanks everybody for joining us here, and thanks to Mark Simon, who is a filmmaker, award-winning filmmaker in his own right, but also very important for me. He's a terrific entertainment lawyer, and we're going to go through a few questions about how to protect your material. So, Mark, my first thing is, sometimes you get questions. I'm sure you get these as well. I got an idea for a movie. A buddy movie about a cop and an orangutan. So, how can I protect my idea? What can I do?
Right.
Protect my.
Well, I guess, and is this interactive? Like, if I ask a question, can people hear me or?
People can hear you. They're on mute.
Oh, they're on mute.
They have a chat window that they can respond. I mean, I can take it out of that mode if you want.
Well, just to start with the basic question, you said, how can I protect myself? So I just wanted to get a sense from people what they understand copyright is and what it affords people. Because there's a lot of misnomers out there, with the little C sign, et cetera. And I want everyone to understand that the mere creation of a work, the expression of the work itself, equals copyright, as opposed to years ago when you had to make certain formalities like the C. So if someone has an idea for the orangutan idea, or the orangutan movie, I should say, the idea by itself, kicking it around a coffee shop, talking about it with friends, even recording it, probably is not protectable. But once they set it down into a treatment or some other story idea, that tangible form is protectable. And if they did nothing else, they would at least be able to have an argument that a third party ripped off their story idea, their treatment, their whatever that is now fixed in a tangible form. Go ahead.
Everyone's going to ask, I think, is, how, when you say tangible form or a treatment, how extensive? I mean, I assume the more extensive, the better, right?
That's exactly right, because the next step would be the registration. And I don't know if I would be getting ahead of the discussion, but, the notion about sending it to yourself in an envelope or registering it with the Writers Guild or registering it with the Copyright Office, all of those are just demonstrative of the expression. In other words, I just told everyone that the mere creation alone equals copyright. So the putting the C on it and registering it allows you access to the courts. In other words, you can't bring a copyright lawsuit until you register a work with the Copyright Office. And also, until you register with the Copyright Office, your proof may be lacking. So those are the reasons that you want to take those more formal steps. And whatever that tangible expression is, the more detailed it is, the better, in terms of trying to show that someone usurped your idea. So, if you have one page versus an entire screenplay, the screenplay is going to be more robust. By the way, all of these lawsuits are very difficult to prove. If people kind of scan all of the lawsuits that are out there with folks claiming that Studio A or Producer B stole their project, it's very, very difficult to prove.
Right. And very expensive to engage in a lawsuit of any kind.
That's right. Often expensive, yeah.
So the written treatment, that was one of my questions. The written treatment definitely helps, and the more detailed, the better.
That's right.
And I assume then the full script is about the best you're going to be able to do if it's specific to a movie idea, right?
Yeah, I mean, the questions might come up about, well, what if someone changed the scene, or they changed the character's name, or they changed the race? I mean, this is all fact-based. So if it went all the way to a judge, he would look at the totality of the facts. And a defense to infringement or copying is not that, oh, well, you know, we changed a little bit of it. It's going to be substantial similarity or copying. If there's copying, that's an infringement, or if there's a substantial similarity, that would be an infringement as well.
Yeah. Now, I don't want to get into too much litigation stuff, but I mean, do you have to prove that to whoever you're alleging copied your material, do you have to prove that they had any access to it? I mean, do you have to show anything there? How does that work?
The general answer is yes, because if you're not able to prove that they actually copied it, you know, if there's not a camera or some other way to actually prove that third party who might be arguing that it's a coincidence or that, the similarity is things out in the public that everyone has access to, and it was, you know, just, again, coincidence. If you're able to demonstrate that the third party had access, that is going to be used as part of the inference to copying. Because again, it's going to be a totality of the circumstances. If you're not able to show that the studio or the producer had access to your work, then maybe it's possible that it really was a coincidence and that this idea is not so unique. So again, access is a key component to this sort of discussion.
Yeah. So tell us a little bit about you mentioned some of these registration processes. So I've expressed the idea. Let's say I've got a treatment, fairly significant treatment. What's the best way to go through that registration process?
So the three concepts that we discussed are mailing it to yourself, which is, sort of evidence that of the date when you created it. And that would be the reason to do that. The WGA registration is also, yeah, go ahead.
You mail it to yourself, and when it arrives, obviously don't open it.
That's correct.
I think that goes without saying, but sometimes you're just excited to get a piece of mail.
So that certainly is a valid step. It's the WGA registration, same thing. The only reason you're doing that is to demonstrate, to have evidence of date of creation. Because if you're ever having a dispute about one of these things, when it was created is going to become, along with access, a very important and valid point. Because if the other party you're arguing with is able to demonstrate or show that, well, actually they created it before you, that's going to be a pretty good defense. And then, of course, the copyright registration is probably the best sort of evidence, because then you've now fulfilled the formality requirement that's needed to bring a suit, et cetera. And it's not very expensive. The rates just went up in the last month, and it's $35 for a single work online. Now you can do it online, and $55 for a standard application for sort of all other filings. And we do that as attorneys, and certain folks who are familiar with the process can do it themselves, even if they're not an attorney. Or you could go online to the copyright.gov and sort of figure it out.
Any reason to do the WGA registration? Why not just do the straight copyright, other than the $35 fee? Well,
WGA registration is probably a whole lot quicker, because when you register something for copyright, you don't actually get the registration for some time because there's a backlog. But but still filing it is proof. You don't have to wait until it actually gets the registration. So that may be one reason to do WGA. The other reason may be that you're early on in the process and you want to file your treatment, but you know that there's so much work that's going to be done, you don't even want to register it with copyright, because again, it's going to change so much but you want some protection as you're talking to people about it.
Now, somebody asked the question. The question was, how often should one recopy their work? In other words, I guess, do you have to? Let's say you've made significant changes to that treatment. Let's say you've now really advanced it, and it's now gone from a 5-page treatment to a 50-page treatment. Is that something that should be re-registered or recopy?
Yeah, I think it's a practical question. I think it really depends on how you're going about soliciting either a producing partner or financing, et cetera. So I guess my point is you don't have to race to the Copyright Office and register it when you're still sort of workshopping it. And that might be sort of back to your last question, the reason to register with the WGA office. But you would want to register it at the time that you're really going out to the public with it in a significant manner. And if it's changed from a prior registration, then yes, you should update that registration.
Yeah, something just occurred to me as we were talking. We are here assuming that this is an original script, that I've come up with a concept for a movie that's original. What if I've optioned? Let's say I've optioned the book, and I have the rights to the book, and now I'm created a screenplay based on the book. What's the difference there in terms of what I need to do to copyright my screenplay?
Well, the Copyright Office, you're going to see in the registration. The short answer is there's not a difference. But what you're going to want to show is the chain of title, for lack of a better word. So you're going to want to show, that's why if everyone out there is familiar with in an option agreement, the short form option. The reason you have the short form option is so that when you register your screenplay, you're going to first register the short form option to show that, well, wait a minute, the reason I'm registering this screenplay is because I acquired the rights via this option agreement. And here's the short form option demonstrating those rights.
Got it.
So that's all part of the chain of title. And when a film is distributed, a distributor is going to want all of that. They're going to also want proof of payment. Chain of title is every little detail that involves showing that when you're transferring rights, the rights were valid. So
let's talk about that for a second. So when I go, when it takes me 10 years to get this thing made, and I've faithfully, re-upped my option every year, and I've paid the writer the option, you're saying I need to have the
proof of payment. Yeah.
Proof of payment as well as the agreements that are signed. Okay.
Yeah. Generally, what you want to do is when you're making those option payments, you're sending it with a letter that says, here's enclosed herewith is option payment number 1 from the period X to Y in the amount of Z.
Okay.
Yeah.
Okay. And just, do I need, if I'm in that scenario, do I need to copyright my screenplay? It is based on the book, and the book is copyrighted.
Yes, because the screenplay is a wholly separate work from the book. So absolutely, you would have to register that screenplay.
Okay. You're making me think I'm going to be doing that tomorrow morning. All right. So we've covered the idea that as you've said, the expression of an idea gives you some sort of rights to that idea. Am I saying this right? Correctly? The expression is first and foremost, and then
the tangible expression. The tangible expression. Yeah. Meaning
writing it down.
Exactly. Or some, in the case of music, the recording of it, or in a movie, the filming of it. But the expression can't just be out there talking,
Well, what if I've now, everybody's going out and writing orangutan movies now because I came up with this great idea. What is the recording of it on video like this? Is that, let's say we're I'm pitching it and somehow that pitch is recorded. Is that tangible proof?
The a recording may be tangible. I mean, that's going to be a fact-based argument that you probably don't want to be in. But the short answer is yes. If it was dictated out and recorded, and you actually were able to date stamp it in some manner that was absolutely provable, maybe you send that tape in the mail as well, and there was an argument subsequently about it, that would be evidentiary material. But again, that wouldn't be the best way to go.
No, okay. Yeah, I know. I seeing as it is it's called screenwriting, I advocate that we actually write the script. But a lot of times you go out there and you pitch. We're in a business where people will buy off a pitch, and writers go into studios all the time and pitch. I guess can you talk about that a little bit?
Well, a lot of it is practical. So you're getting into the whole NDA world, non-disclosure agreements, and you get questions from folks who are starting out in the business. Hey, I want to go out and pitch this, or I'm going to give it to so-and-so, my brother-in-law's in the business. Do you have an NDA that you can provide me? Or I have an NDA that I want them to prepare. 9 times out of 10, anyone who is in the industry and substantial and working, they're not going to sign an NDA because of the risk of suit. Conversely, if you go and pitch a studio or production company without representation, so like a cold submission, very often that production company, that agency, they're going to require you to sign a letter saying that you're not going to sue them, and that if they have a similar project, that it's not going to be an infringement, it's going to be a coincidence. So how do you get around these issues? Well, one is if you're represented, that helps, because if an attorney or an agent or a manager is making your submission, very often, most of the time, you're not going to have to sign that document. In the reverse, how do you protect yourself from getting ripped off? Number one, you can register that pitch. Again, the more detailed it is, even if it's a treatment and you had registered it and then you're pitching that verbally to a studio that ends up making something that's almost identical and you're not attached to it, you still have evidence that, well, look, on this date I had this meeting, here's my registered pitch or treatment or story. Then you have a fight on your hands. But that would be some protection. And the other point here is knowing who you're dealing with. If you're dealing with reputable people, hopefully you're not putting yourself in a position to be, to have your material stolen. But there's risk. There's risk of doing business. And if you're not represented, that can happen. And people have had their material taken.
When you're talking about representation, you're talking about an agent or a manager, basically.
Or a lawyer. Or yeah.
An attorney who would set up how does that work? Because obviously, it's not easy to get an agent or a manager when you're starting out, but I can engage services of a lawyer. Would a lawyer be an intermediary in a situation like that ever?
Yeah, I mean, I'm asked on behalf of clients sometimes to submit material.
Okay. Okay. Right. Now, what about the idea? Because someone's asking, and it's up on the screen now. What about the idea of you're working on something, and somebody's helping you, your friend's helping you out, or this does enter again into this NDA world, but
right. I mean, that's where the NDAs are a little easier to come by. When it's internal, so to speak. If you're asking someone to work on your project and they want to get experience or they just want to work on it, that's where having that party sign an NDA is a little more accessible or feasible. And also, you can have them sign an agreement that says essentially that the services they're providing is on a work for hire basis, and that you own the results and proceeds of their contributions. So also that agreement could have NDA language as part of it, that they're not, confidentiality language, that they're not going to discuss what they're working on.
Right. So what I'm hearing is it's a good idea when you're working on something with other people to make everyone's roles clear and to go as far as documenting it with some sort of a letter.
Yeah, I mean, out of anything we've talked about so far, in terms of the indie world and the sort of basic sort of things and stuff, I would say this is the biggest issue, because this is where people actually have disputes and arguments and expectations and understanding change. And people forget, people might think one thing when they start working together, and 9 months later, one party or both parties thinks the relationship is different than when they started. So this is probably the most important point that we've talked about.
Okay. And how do you manage that? I mean, two people come up with an idea. Obviously it would be great if you get a lawyer involved as soon as possible, but a lot of times it's not feasible from a financial standpoint. What do you suggest?
Well, I certainly, you said if two people are working on an idea together, which is slightly different than getting someone to work on material, but in either case, I do recommend getting your intentions and understanding down in writing. I mean, if you absolutely can't hire an attorney, because sometimes you could hire an attorney for a very basic term sheet. You could go to an attorney and say, look, I understand that, we might not be your first priority. We want to keep this as affordable as possible. And we just need some guidance setting down something very basic. If you don't expect that attorney to do it immediately, if you can give the attorney some time, because you're saying, look, we can't afford a big agreement, but we just need something down. And, if we give you a few weeks, do you think you could give us something at a very affordable rate? Someone like me could probably get an associate to put together a very basic understanding that would clearly and simply define the roles, the intentions, the approvals of the parties, and most importantly, ownership. Are they co-owners or are they not co-owners? Does one party have ultimate approval or not? That can be done affordably. And if the parties don't want to get an attorney, they should try to, as simply as possible, write it down themselves, not try to become lawyers, but just hit the very bare basic points that hopefully, if there's a disagreement down the road, they can look back towards that document.
Right. And essentially, the basic points are ownership and control, and I guess along with ownership comes the financial, or do we need to, lay that out to some sort of financial, even if we split everything 50-50?
Or that you're going to, mutually determine before expending any money, things like that.
Right. Someone asked about what...
And maybe what happens if you don't succeed in working together, or maybe you set out goalposts, that we're going to, if we can't complete whatever it is we're trying to complete in 6 months, everything's going to revert back to me,
Right. Someone's asking about crew members, and is the work for hire language in a crew deal memo, is that the protection against the crew's, the way the question is put, does it enable a clean chain of title? But can you talk a little bit about that?
It is necessary for a clean chain of title in terms of delivering the project and or making sure the crew member isn't trying to state that he has more than you think he's entitled to. I mean, I've seen these disputes, especially on smaller films or documentaries where, you know, the cinematographer or the editor is taking on a greater role, and the next thing you know, they're trying to claim ownership in their results and proceeds. So, yes, it protects against that. It doesn't protect against the disclosure of the confidential information unless that language is in the agreement.
Mm-hmm. Okay. I'm gonna open up the discussion, and we have. I don't want to. Again, we said we would take as little time as we could here, but I'm going to open up.
Only because I'll still be working here late at night.
All attendees are unmuted.
Okay, so what I did is I just unmuted, so there's going to be a lot of background.
All attendees are muted.
All right. That didn't work out. Okay, so I guess what I'm going to do is, for my attendees, if anybody has a question now, if you could just type it in for us, because it seems not practical to unmute everyone. So I guess, Mark, what you were saying, the biggest area of disputes that you see in the independent side is this thing of people who have worked on a project and who have that misunderstanding about what their role is, or.
Yeah, I mean, I don't want to say it's what I see the most. I just think it's the most fundamental issue that has a practical consequence with, you know, independent filmmakers, because there's more likelihood to be a dispute there, which causes a problem, as opposed to all the way that a artist or creative believes a studio has stolen their property. You know, that's a harder circumstance. That's not as frequent. So that's what I meant.
And it is also, from a practical point of view, it's very difficult to prove, and it's very expensive to
That's right.
engage in that kind of a lawsuit.
Yeah.
So that's also probably why you don't see it all that much.
Yeah.
Did you have anything else that you wanted to? Any other words of wisdom? We've got some. Oh, I've got another question. You know, this is the usual question when you're talking to independent filmmakers. You know, what can you expect to pay for per hour for an associate? I mean, I'm not asking you. I mean, obviously that's, you know, I don't want to get into pricing here, but you know, is it feasible to think that I can get something done in the, you know, under 1,000, over 1,000?
Yeah.
What range?
I think for it depends on the degree of communication you would need with the attorneys. So if you come to the attorney and have really thought about and reached agreement on a lot of these issues that we're talking about, then the attorney's time is reduced. For a very basic understanding, it's possible to get it done for under 1,000. And, you know, I think $500 is not so realistic. I think under $1,000 can be accomplished. I think 1,000 to 1,500 is definitely doable for very basic agreements. You know, the junior associates at my firm are in the $200 an hour range, you know, between 200 and 300. So, you know, a lot can be accomplished.
Yeah, I mean, I like to think that, I mean, what I like to try and do myself is I like to make sure that I've negotiated the major points, so that I'm not asking an attorney to come in and start negotiating. You know, I mean, you can't leave you can't cover every point, but certainly the major ones, so that the attorney's coming in and really, you know, putting the paper together correctly and finding all those things that, you know, that I wouldn't normally pick up. But
yeah.
Just to be clear with everybody on the line, the more you ask someone to negotiate on your behalf, that's where you're going to get into trouble in terms of cost. It's just practical.
Yeah.
I have another question. After the script is protected and you head into production, is there anything else in terms of protecting ideas? I know I have some folks who are working on some sci-fi things where it has where there are very unique elements in terms of the characters that they're creating in terms of wardrobe and look and feel and all that.
I mean, that is where you can get your crew and or your VFX house to enter into confidentiality provisions and non-disclosure type agreements. And that happens for a variety of reasons. Sometimes you don't want it leaked for publicity purposes. Sometimes it's because you're doing something unique. So, again, when it's internal, that's where it's easier to get those provisions signed off on.
Right. And probably that part of that, it's a good idea to restrict. I mean, I think it's standard language now to restrict photo taking or no videos, no recording, anything during production.
But I'm looking, the question says, once you head into production, what are the next aspects of the film once you worry about and look into copywriting? I mean, there's nothing else to copyright. You copyright the script and the film, and the components of those are protectable.
All right. One last push out to everybody. If you have a question, if you want to type it in, because I see our time is coming to an end with Mark. I want to thank you, Mark. I learned a couple things. Like I said, I have a project where I did just that, and I've got a screenplay based on a book, but we haven't copywritten that screenplay. And that's something I learned tonight.
Right. Though the only practical issue I would say there is your option on the book probably prevents someone else from going and infringing because you're, sort of practically protected because the underlying rights holder can't go and give the rights to someone else. So there is some practical protection there.
Yeah, I guess there's practical protection, but I feel like I would be one step removed from that process because if someone was infringing, they're infringing on their copyright, and I kind of have to rely on them to do something. Is that true, or
what did you?
Well, let's say someone did infringe on the copyright in the book.
Right.
What's my position? I've optioned the book. Do I have I mean, not that I would sue, but would I have a valid legal position as someone?
I think it depends on the facts. I mean, if the underlying rights holder optioned the rights to you and optioned the rights to that party B, obviously you would have a clear action against the party, the underlying rights holder. If party B started, producing a film based on the underlying rights and didn't actually obtain those rights, then obviously the underlying rights holder has an action against that party. And it'd be difficult for you because you're not in privity, you don't have an agreement with them, but, you've definitely been aggrieved. But the short answer is there's no doubt for chain of title purposes, your script does eventually have to be registered. Absolutely.
Yeah. All right. Well, Mark, I really appreciate you taking the time to answer these questions. I think it's been really helpful.
My pleasure.
All right. Well, thanks so much.
Bye-bye.
All right. Bye. Guys, does anybody on the line have any questions that I can answer? I will try the listen only mode again, but be prepared. Okay. Does anybody out there have any questions? So you'd have to unmute your mic if you do. Okay. I'm not hearing any questions. So I think hopefully this has been helpful. You guys, of course, can always email me. We'll see each other at the next meetup. And thanks so much for joining us for protecting your material.